All right, Commissioner Bukacek, can you hear us? Commissioner O'Donnell, can you hear us?
Yes, sir.
All right, thank you. Vice President Fielder, can you hear us?
Yes, I can. Thank you.
Okay, Commissioner Bukacek?
I can hear you. Thank you, sir.
All right, very good. All right, let's get started. All right, good afternoon, everybody. Time is now 1:31 p.m. Today's date is Tuesday, September 3rd, 2024. This is the time and place for our regularly scheduled business meeting. We are in the Bollinger Room at the Montana Public Service Commission. I will call this meeting to order. Would my colleagues join me in reciting the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America, to the republic for which it stands one nation under God, indivisible, with liberty and justice for all.
All right, thank you, colleagues. I would note for the record that Commissioner Pinocci and myself are present in the Bollinger Room. Vice President Fielder, Commissioner Bukacek, and Commissioner O'Donnell are participating online. Therefore, we do have quorum today. Montana Public Service Commission welcomes public comment on any matter that is on today's agenda or on any matter that is within the jurisdiction of the Montana Public Service Commission. Are there any public commenters in the room? Good afternoon. Please come forward and state and spell your name for the record. There should be a little button. There you go. Thank you.
Thank you, President Brown. Commissioners, for the record, my name is Chris Cooey, C-O-U-E-Y. I'm a resident and property owner up in the North Star subdivision. I know that that's not on the agenda today, mostly probably because they haven't submitted their plan to you, even after an extension. I already had the day off of work, so I decided I'd come and make my comments anyway. There's a couple of things I'd like to point out, and the first one is in regards to this plan itself. A few weeks ago, I made public comments, and I think some of the point of what I said was that this utility doesn't care. They don't care about the residents and the property owners that they're serving. And clearly they don't care what this commission has to think about them, as they were granted an extension, which I think was insulting in the first place. They've had over a decade to address this problem. They were given an extra week because of, from what I understand, something to do that they couldn't get somebody out to drill in time and check wells. Sounds like a them problem. They were given a deadline. I know that when I have deadlines at work, I just have to get it done. So they should have paid whoever they could have paid, found somebody else to come and look for the original deadline. And maybe we would actually have it on an agenda today to talk about. So I think the fact that they didn't even take the time with an extension to provide that plan to update both this commission and the neighborhood itself is just completely irresponsible and negligent on their part. It shows that they don't care what anybody has to say. I can tell you they did have time to come out last weekend and update their signs. And when I say update their signs, I mean they brought a Sharpie and they emboldened the words that were already there that say no watering. That was the extent of their updates to signs. So the other thing I'd like to touch on, I think, is that this utility has been allowed, I think, to hide behind the rules and laws that they point out of domestic use. I've read the definition of domestic use myself, both for the U.S. Geological Survey and in the Montana Administrative Rule. And lawn watering and irrigation for gardens up to 5 acres is in the definition of domestic use. It's pretty clear that what we want as a community is perfectly within the confines of what they're required to provide us under the same rule that they're using to defend themselves. So, I mean, as the former budget and revenue officer for the city of Helena, I've done water rate cases myself. The industry practice that they provided however many years ago now at the hearing that took place, I think back in 2020, right? They cited that it's an industry standard to take your wintertime water use, right, and say that that's your average monthly use, and that's what your base rates are based on. And that's absolutely true. It's the same thing we do at the city. but it's a rate case. That's what you use to establish your base rates. And then everything above that is the additional charge. It is not an industry standard to use that practice to determine how much water you're required to supply as a domestic use. So I think that those 2 points are really things that they hide behind that they're wrong about. And I think that they should be pointed out to them. And honestly, I think that this commission should be completely fed up with this utility. I've heard comments as to that much the last few weeks from more or less all of you. And I think their disdain is prevalent by not providing you with the plan that you asked for, both in the time you asked for it and the extended time that you asked for it. And so I may not speak for the neighborhood, but I can tell you that I'm sure they all agree with me that we'd love to see fines, sanctions, and forcing of them to finally address the problem. I mean, I'd go as far as to say that I want to be compensated for the yard that I'm going to have to replace eventually when this problem is solved. So I submitted some pictures with my public comment a few weeks ago, and I don't know if you all have seen those or not, but I'm happy to provide them again. You can see, even on our even odd schedule that we were allowed to have last summer, my yard was fine. They took that away this year. We're down to the 2 wells. I get it. I don't water. My yard is gone. So I appreciate your time. I'd also like to just make sure I get on the record to thank Tina, Patricia, Grant, everybody here that's working. They've been not only helpful, but patient with my emails and phone calls, text messages. I can be a little persistent when it comes to trying to find out information. So I appreciate that. Thanks.
Thank you. Thank you for your public comment. Any other public commenters in the room? Any other public commenters in the room? Seeing none. Any other public commenters online? I'm informed there are not, so thank you for the public comment today. There are no changes to the agenda for today, so we'll move right into our action items. Action item number 1 is approval of the commission minutes for the week of August 19, 2024. Is there a motion, Commissioner Pannocci?
I make a motion to approve the minutes.
Is there a second?
I'll second the motion, Mr. President.
All right, Vice President Fielder has seconded. We have a motion and second. Discussion, revisions, edits. All right, seeing none, all those in favor of Commissioner Pannocci's motion to approve the commission minutes for the week of August 19, 2024 as the final minutes for that meeting, signify by saying aye.
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 All those opposed, signify by saying no. Seeing no opposition, minutes are adopted 5-0. Work session item number 1. This is docket 2021.12.136. This is a commission initiated matter. This is the CenturyLink investigation. We're here to consider extending the deadline for appointed commission staff to negotiate with CenturyLink and the Montana Consumer Council. Who's presenting? All right, Mr. Poco.
President Brown, Commissioners, before you today is a notice of commission action, which if approved, extends the deadline for staff to complete negotiations with CenturyLink and the Montana Consumer Council. Just a bit of history on this one. This docket regards the investigation into CenturyLink's legacy infrastructure. The commission held a hearing last year on September 11th, 2023, and eventually issued a final order in this matter, which rejected both CenturyLink's proposal to resolve the matter and MCC's alternative proposal. Previously this summer, the commission has appointed the executive director and allowed the executive director to appoint staff to negotiate with CenturyLink and the MCC to find a resolution to this docket. The staff has been engaged in those negotiations, and this was last extended last month to conclude on August 30th. And this notice of commission action extends that deadline once again to September 30th, 2024. Based on the discussions and the amount of discussions being had, it's of staff's belief that 1 extra month should hopefully conclude the negotiations. Staff recommends that the commission approve the notice of commission action and allow for any non-substantive edits required for clarity.
Mr. Sanders, anything to add?
The only thing I would add, Mr. President and Commissioners, is that September 30th will probably conclude this proceeding one way or another, at least from a negotiation standpoint. We do not intend to seek an additional extension after the September 30th deadline.
Okay, thank you. Is there a motion? Commissioner Panoche?
I'll make a motion to support staff recommendations.
All right, is there a second?
I'll second the motion, Mr. President.
All right, Vice President Fielder has seconded. Discussion? Questions?
Mr. President?
Commissioner O'Donnell?
Yes, I appreciate the summary given by Mr. Polkow. I wanted to point out that from my discussions with Mr. Sanders in particular and other staff members is that there has been very strong communications, deliberations on the part of our staff, and the report of Mr. Polko didn't seem to me to indicate that we've been working very, very strongly, taking this very, very seriously. And my impression is that CenturyLink, as the reason for this is that they're dragging their heels on this whole thing for reasons of insufficiency of their system to be renovated. However, there does need to be a resolution to this. It needs to be done in the favor of the public interest. And I think that Mr. Sanders and the other people, staff members involved in this thing are working very hard in that respect. And I, for one, am very, very, very anxious to see this resolved, in that, as I've mentioned before several times, the issue here is the ability of the CenturyLink customers to access 911. Anything short of a solution to that is raises very serious problems with me. So I'm reluctant to support this. Another delay on this has been going on for quite some time, but I will, because I have confidence in our staff that at this point they're going to lay down the gauntlet and just say, this is the way it's going to be. Thank you, Mr. President.
Thank you, Commissioner O'Donnell. Additional discussion?
Mr. President.
Vice President Fielder?
Yes, thank you. Question for Mr. Sanders.
President Brown, Vice President Fielder, yes, what's your question?
Thank you. I appreciate the way this draft order is written, and it notes that the September 30th deadline is the deadline for staff to conclude its negotiation work. Can you give us an idea? Do you have a schedule in mind for when that recommendation would be brought to the commission so that we can actually make a decision on this and close it out for good?
Well, President Brown, Vice President Fielder, we have a negotiating session. We have additional sessions scheduled for next week. They are our counterparts in this at CenturyLink are gathering some information, which we requested of them. We're going to get together next week and go over that information, and we'll make a determination at the conclusion of those negotiations early next week as to whether or not further progress can be made. If progress can be made, we will report that back. If it cannot, then it may very well be the case that we conclude negotiations at that time and we move to some alternate resolution which the commission could consider.
All right, thank you. That's helpful. So I'm sorry, Mr. President.
Mr. Polko would like to address your question as well.
Okay.
President Brown, Vice President Fielder, just to add to what Mr. Sanders stated, is that currently this stands in we've had a motion for reconsideration in this docket. So if negotiations are not successful, a draft order on reconsideration would be before the commission. And then if negotiations are successful, the commission will consider staff's recommendations on those negotiations. Hopefully, either way, it can be resolved within a few weeks of the conclusion of the negotiations themselves. But that's where we currently stand in the procedural posture of this docket.
Thank you. So, Mr. President, it sounds like what we're hearing is that we may have this back on the agenda before this September 30th deadline. Is that correct? Am I hearing that correctly?
Mr. President, Vice President Fielder, I would say that is a possibility, but it's unclear as to whether or not that will be the case.
Okay, thank you.
All right, additional discussion or questions? Additional discussion or questions? I will join my colleague Commissioner O'Donnell in stating that I will support this motion today, but I do so reluctantly. We have more than ample, given more than ample time to try to resolve these matters. I do sense a bit of foot dragging, even though I haven't been part of the negotiations on the part of CenturyLink. I would state that I am fully aware of the number of public comment and complaints that are still coming in on this company during this interim period where we have abated our order from the spring. So I would like to see this move to a conclusion, much like Vice President Fielder, in a more expeditious manner. And I agree with Vice President Fielder. I would be unlikely to vote for another extension. Additional discussion? Additional discussion? Seeing none, all those in favor of Commissioner Pinocchi's motion signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, gentlemen. All right, let's move to work session item number 2. This is docket 2024.07.072. This is commission initiated matter. This is involving rulemaking on the part of the agency. We're here to consider finalizing the amendment of Administrative Rule of Montana 38.2.101 pertaining to the model procedural rules. Amanda.
Good morning, President Brown and commissioners. My name is Amanda Webster. I'm a staff attorney with the Department of Public Service Regulation. The rulemaking that's before you today is primarily a matter of housekeeping. Back in July, the commission approved a notice of proposed amendment regarding this rulemaking. That rulemaking was published in the Secretary of State's Administrative Register and sent to the Interim Legislative Committee. There was also a public comment period, and the commission received no comments or requests for additional procedure during the comment period. Thus, I am requesting and bringing before the commission today a notice of amendment, which would finalize this proposed rulemaking. Staff recommend that the notice of amendment is approved, and if it is approved, staff will publish the notice in the Montana Administrative Register, and the rule will be finalized, if approved by the Secretary of State, by approximately September 21st of this month. The purpose of this rule, as stated in the proposal notice, is to clean up our rule referencing model procedural rules. The Secretary of State's office and Attorney General's office has published model procedural rules to implement the Montana Administrative Procedure Act. And in June of 2024, the Secretary of State repealed some of the model rules that the commission had referenced in our procedural rules. So this is just a cleanup to remove references to repealed rules and meet other requirements for our administrative rules such that we have the correct implementation citation and removing and also adding a reference to where the rules may be obtained, which is from the Secretary of State's website. That's all I have for you today. So I'd be happy to stand for any questions. Thank you.
All right, colleagues, I will move to approve the draft notice of amendment and authorize staff to make any non-substantive changes required for publication in the Montana Administrative Register. Is there a second?
I'll second.
Commissioner Pinocchio
Second.
has seconded. Okay, motion and second discussion. Discussion. Seeing none, all those in favor of my motion signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Ms. Webster. All right, let's move to work session item number 3. This is docket 2024.04.041. This is Speed Dumpster LLC. We're here to consider and hear the application for Class D motor carrier certificate and to issue a decision, consider issuing a decision on Protestant Evergreen Disposal Inc.'s motion to dismiss and strike. Ms. Webster.
President Brown and Commissioners, before you is a draft order on motions for sanctions. This is regarding Speed Dumpster's application for Class C motor carrier certificate of public convenience and necessity, requesting authority to transport garbage within the city of Kalispell and a 20-mile radius thereof. As a little bit of background in this matter, Speed Dumpster filed their original application in March. There are 2 protestants in this matter, Evergreen Disposal and Allied Waste Services of North America, doing business as Republic Services. A procedural schedule was issued in this matter, and the protestants issued data requests to Speed Dumpster in May. The original data requests had a response due at the end of May. Speed Dumpster failed to respond at that time. The parties worked out an extension to the initial response by Speed Dumpster. Those negotiations went back and forth for the month of June. And in July, the commission ended up issuing an order compelling Speed Dumpster to respond to those data requests. The commission set a deadline of August 9th, 2024 for Speed Dumpster to respond to the data requests. In that order, the commission noted that it would consider sanctions if Speed Dumpster failed to respond. Speed Dumpster did file a response to the data requests by the deadline. However, Evergreen argues that those data requests were insufficient. And so Evergreen filed a motion for sanctions and motion to dismiss the application, which we are deciding today. Speed Dumpster filed a response to that motion. And Allied did not file a response by the time this order was drafted within the 5 days allowed for responses to motions. However, I would add a footnote to this order as a clerical edit that on Thursday, August 29th, Allied did file a notice of joinder to Evergreen's motions to strike and dismiss, which did not contain any new legal or factual arguments, but just joined the motions and brief in support filed by Evergreen. So to take you through what Evergreen is requesting in its motions, first, they are asking for a motion to strike documents filed by Speed Dumpster through Mr. Sutherland, who is the sole owner of Speed Dumpster, because Mr. Sutherland is not authorized to practice law in the state of Montana. Generally, all business organizations, including limited liability companies, which Speed Dumpster is, must be represented by Montana licensed legal counsel in order to appear in legal actions. Business organizations cannot appear through self-represented or pro se individuals. Evergreen argues that because some of Speed Dumpster's filings submitted by Sutherland constitute the unauthorized practice of law, the commission should exercise its discretion to reject non-compliant documents. To address this first, staff recommend that the commission deny the motion to strike because it is not necessary for the commission to strike Sutherland's filings from the record in order to give them the proper weight that they deserve. There's a less severe option available, and that would be to not consider any of Speed Dumpster's legal arguments or objections made through Sutherland. To move on to the second request is a motion to dismiss. Evergreen requests that the commission dismiss Sutherland's application entirely as a sanction for its failure to respond to data requests as ordered. Staff agrees with Evergreen that Speed Dumpster failed to respond to a number of questions that it was ordered to respond to, and many questions that failed to respond to the subparts. Staff agrees with Evergreen that the protestant has a right to get a response to their data request so that they can form a defense to the application and to know what requirements Speed Dumpster has to meet the elements of fitness and other requirements for the Class D application. Staff notes that the commission should take discovery abuses seriously, but we also note that any sanctions that are imposed on Speed Dumpster should be proportionate to the harms that it caused to protestants in this matter, and should also be consistent with what the commission has previously warned Speed Dumpster would happen if it did not comply. Because it has been some time since the data requests were initially due in this matter, and because Speed Dumpster did attempt to make a response, staff recommend that the commission exercise its discretion and not dismiss the application as a whole, which would be a severe and extreme sanction for Speed Dumpster, which is appearing to work with the commission and the protestants in this case to move the proceedings forward. Speed Dumpster has been responsive. They did attempt to respond, although they did not do so adequately. Accordingly, staff recommends that the commission deny the motion to dismiss Speed Dumpster's application, but the commission should consider Evergreen's alternative request in one way, which would be to stay further proceedings because a hearing in this matter is scheduled for the end of the month to start on September 30th. Deadlines are fast approaching for pre-hearing memos. And because the protestants do not have the information they need to move forward, staff recommends that proceedings should be stayed and the hearing at the end of the month vacated. Staff also recommends that the commission set a deadline for about 1 month from now for Speed Dumpster to notice Montana licensed counsel appearing on its behalf in this matter. If Speed Dumpster does not meet that deadline of October 4th to file a notice of appearance of counsel, staff recommends that this matter should be dismissed without prejudice, which would mean that Speed Dumpster could refile an application in the future. But if that deadline is met, if Speed Dumpster does file a notice of appearance of counsel, staff recommend that that counsel should respond to the data requests within 2 weeks of that notice being filed. I'd be happy to stand for any questions at this time. Thank you.
Thank you, Ms. Webster. Is there a motion? Commissioner Bukacek.
I make a motion to approve staff recommendations and issue the draft order with any necessary edits.
All right. And is there a second?
I'll second the motion, Mr. President.
All right. Commissioner Vice President Fielder, second. I'll recognize that one. We have motion and second. Discussion, Commissioner Bukacek.
And this was another great teaching case for me, this time regarding Montana laws that govern the practice of law. And so thank you, Ms. Webster, for your diligence and your assistance. And the arguments for staying all further proceedings in this matter and setting a deadline are well explained in the draft order, so I don't need to say anything more about that. I agree with Mr. Sutherland giving him another month to seek legal representation, and I do not think sanctions are appropriate since I have no reason to believe Mr. Sutherland is intentionally circumventing legal protocols. So, and also hopefully these things can be resolved with less severe measures. So for these reasons, I stand by my motion to approve staff recommendation and the draft order as written.
Thank you, Commissioner Bukacek. Additional discussion? Additional discussion, questions? I have a couple questions for you, Ms. Webster. Was a status conference held in this proceeding previously?
President Brown, staff did not hold a formal status conference in this matter, though staff has had multiple email chains with the protestants and Sutherland for speed dumpster since the beginning of this proceeding.
Has the commission notified Mr. Sunderland of what the requirements of Montana law are in terms of representation?
President Brown, in an email staff sent to Mr. Sutherland in May after he had filed his application, staff noted to Mr. Sutherland that he needed counsel in order to make an appearance and for hearings before the commission. The commission's actual rule is that all practice before the commission, which constitutes the practice of law, must be done in accordance with Montana rules governing the practice of law, which may be a bit broader than just appearances and hearings. In this case, we found that making legal objections in response to day requests does constitute the practice of law.
Okay, additional discussion or questions? Discussion or questions? Seeing none, all those in favor of Commissioner Bukacek's motion signify by saying aye.
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 All those opposed signify by saying nay. Seeing no opposition, motion carries. Thank you, Ms. Webster. All right, that concludes our work session items for today's business meeting. I would note for record and for public awareness that our next commission business meeting will be Tuesday, September 10th, 2024 at the regularly scheduled time. Seeing no further business to come before the commission, the time is now 2:02 p.m. We will adjourn today's business meeting.